Do you agree with me?
I do, Your Honor. I agreed with you 10 minutes ago.
Okay. So. All right, and ladies and gentlemen, I correct that. It's my understanding one of the panel members has a 9 o'clock, is it dental appointment, sir?
Yes, Your Honor.
Okay, right. And no, is it 9?
8. It's 8.
Oh, 8, okay. Ma'am, what do you think we should start at 10? You think 11, 9:30? What do you think, ma'am? What do you want to do?
I'm gonna get there as soon as, they told me to get there at 8 o'clock. I told them I did have jury duty. They couldn't give me a time on how long I could be in and out, just depending on what, if they have to do anything.
And tell me this, how far away is it?
Land, the VA.
Okay, I understand.
You know, we could use the time to go over the jury instructions and finish
Yeah,
that.
I mean, no,
That'd be great.
ma'am, we're gonna make sure you get done what you have to get done. Understand that?
Yes, sir.
And that's what we're gonna do, so I'm not worried about that, so we'll use the time. Do you think 11 safe? I don't want you to rush by. What do you think, or 1 o'clock?
10:30 is our normal time, is fine. Sure.
Are you sure? You sure? Okay, this is what we'll do. We'll set it for 10:30, but if you're running late, we're gonna wait for you. Don't rush, you promised me.
Yes, sir.
Yeah, we're gonna wait for you, right, everybody?
Yes, sir.
Yes. Okay. And you promised me you're not gonna rush. Okay, just wanna make sure you're taking care of it. I truly do. And so that's what we do. And so anyway, all right, how about this, counsel? Every hour counts, right? It does. And the jury will be here at 10:30. We'll work tomorrow 9:30. How's that?
Sounds great, Your Honor.
Sounds good, Your Honor. Thank you. All right. Okay, now I can't forget the admonishment. And Mr. Marshall, thank you for reminding me of that. I really appreciate that. I do. Anyway, ladies and gentlemen, you're admonished not to converse amongst yourselves or with anyone else on any subject connected with this trial, or to read, watch, or listen to any report of the commentary on this trial by the persons connected with this case, or by any medium of information, including without limitation, newspaper, television, radio, social media. Remember the prohibition as far as Facebook and Snapchat are concerned and so on, or to form or express any opinion on any subject connected with this trial until the cause is finally submitted to you. Lastly, ma'am, I don't want you to rush. I really don't. I just want you to know that. If you're running late, we'll be fine. You understand? We're gonna wait for it. We have great accommodations for the jury. Right, we'll put you in the All right, that's what we'll do. I don't want you to rush. I'm just telling you that. Okay, all right. So.
All rise to the departure of the jury.
Jury is clear, please be seated, thank you.
All right, so tomorrow morning at, what time again?
9:30, Your Honor?
9:30, some more tomorrow, and we get done with it. Because all they have is status changes.
Oh, thank you, Your Honor.
Last word. What do you do, you know?
Can we review the witness list real quick?
Yes.
You have two requests.
I'll just keep over here.
Witness list.
Who you guys doing call tomorrow?
We were wanted to call.
Your Honor, can you excuse the witness?
Yes, we can. sir. Mr. Robbins, thank you for reminding me of
Jason, Dr. Jason Babcock. Sir?
that. Yes, I'm sorry, so you excuse me. You can sit down and you walk around and wait and
Dr. Fortovoff. And Laura Brown.
I went back and looked at the 16-week disclosures, and he is not.
Actually is on all of them. We filed all of our 6.1 in one consolidated cases called Henry. That one has her listed starting the third witness list. That is a case that is consolidated with all of the other cases, and then she is on this particular one. As the order says from Judge Howell, they are consolidated cases. We put them in that one. They have been on notice. We have provided those notices to Plaintiffs' counsel. We have done all of them that way. And And then we did, and so that we have been in compliance with 16.1 with regard to our witnesses.
That's not quite right.
Okay? That's what the order asks us to do it that way.
If it, first of all, the cases are not consolidated. Second of all, if it's a witness that was supposed to be in this case, it should have been filed. 61 in this case. At a minimum, it should have been filed in the lead case. They didn't get one. They filed it in January. In case it's not going to trial, I think it's going to next September, a year from now. So, you know, how am I supposed to know?
Please let them know you have it.
Yeah, I mean, and then on top of that, I mean, the disclosure that she has for here is that she works for Hanna, some kind of analytical position, and so we're dealing with the Milwaukee meter. So I think what they're really trying to do is bring in this Hanna person to be a meter expert. There should have been an expert report for this. This is going to be any type of expert test, so I think it is going to be expert. So for all these reasons, I would think this person.
Better again, we complied with exactly what was required under consolidation order.
I need to see I need to see where, but
She's an employee of Hanna, and she's a rebuttal witness to the testimony that's been given so far.
I appreciate that. Wait, what does that mean? The rebuttal is just the test? Because here's my point, typically you see rebuttal, number one, we're not a rebuttal. Secondly, if the rebuttal expert, we report against, how was she how was she designated? What did it say she's going to testify?
I'll give you that exact language, Your Honor. One moment, please, pull up the indulgence.
Here, I have it. It is anticipated. You know, that's the other problem. They listed 3 different witnesses that are one under one. They have Silvaggio, Samantha Trainer, and application scientist, and Laura Brown, and application and sales. And then they have 4, and then the NRCP 36. Okay, custodial reference. All right, we didn't take a 36 deposition. I don't know what that is. And then in the disclosure, they say these witnesses may have discoverable information about the defendant, the manufacturing and sale of the MW500 meter, as well as information and knowledge regarding the facts and circumstances of the case at issue. That's all it says. Discoverable information about defendants, the manufacturing and sale of the meter. And when I took Mr. Brown's deposition, I asked him who each of the employees in Milwaukee were. This person wasn't an employee, referring again to Laura Brown. So I'm at a complete loss as to how they think you can come in and say anything about this MW500 meter, unless it's some sort of expert opinion. But again, there's no report.
Your Honor, we'd like an offer of proof as to what this person is going to testify to and whether
It is anticipated that this NRCP 30B6 witness and or custodian will testify to the creation and maintenance of the records as to the ordinary course of business, the history of the business, the activities of the business, the operation of the business, the employees of the business, and the volunteers for the business, and she has been identified as a Hanna employee.
Well, that's for the NRCP 36, that's the 4th one down. She's the 3rd one down, okay? She's the line I just read. May have discoverable information about defendants in the manufacturing and sale of the MW500 meter, as well as information and knowledge regarding the facts and circumstances at issue in this case. That's it.
Your Honor, the deposition of Ms. Brown could have been taken, we made her available if you wanted to, we made other witnesses available if you wanted to. So, I don't know why they didn't take her deposition. I understand that they'll.
because she wasn't disclosed in this case.
You know, and trust me, everybody, I understand Rule 16.1. I understand the disclosure requirement. I mean, I get it. I practiced it. I guess there's 2 of
hand
us.
it to you.
Oh, yeah, well, I'm gonna wanna see, make sure I have a copy, but here's my point. I practice, there's only probably 2 of us in the room that practice pre-16.1.
Right.
Right? And Mr. Kemp, they probably don't remember 16.1.1. And the changes to
It
Rule
was
16.
better before 16.1.
Yeah, exactly. You know what, it really was better. I think job as trial judges was much better, I really do. You know, request for trial settings, a note for trial docket, all that stuff, it just made things a lot easier, it really did. And actually, 41B, the 2-year one of prosecution had some meaning. Then,
Your Honor, my only indulgence for the court is if you are going to rule that she should not be allowed to testify, I'd like to know that now because she did fly all the way out here from Rhode Island to be here to give testimony.
What's the offer of proof number 2?
I just read to you what she's going to testify about. We didn't mean this to be as a matter of surprise. We anticipated that the deposition would take
Creation
place.
names on record.
I'm gonna get cut off again.
no, I'm gonna listen to you.
That's okay.
But-
I don't need to listen to anymore.
No, but I mean, here's the thing, and understand this, I mean, from my perspective, in a general sense, as a trial judge, I'm kind of being blindsided. And what I mean by that is this, I haven't had a chance to look at the order, I haven't had a chance to look at the designation, I haven't.
All over there.
You see what I'm
Yes,
saying?
you're right. You're right on that, Your Honor. She will be here tomorrow, and if you need, we'll get you the order on that, how things, what the order says from Judge Al, because that's really what you need to see first. I get it.
Yeah, I mean, and so my point is, you want me to make a decision, how can I make a decision
Without
without
the
reading
order.
all the orders, number one?
Yeah.
Number two, and Mr. Odou has a fairly simple request, because he said, Judge, what's the offer of proof? As far as what is she gonna testify to? You know, and my point is this, I realize her deposition wasn't taken. Maybe there could be some confusion as far as how this whole thing was consolidated for the purposes of discovery and the special master order, then we have Judge Alf's order. You see where I'm going? And so I don't know what's contained in the order. I mean, I'm just at a disadvantage. I am, and so I don't want to make
I agree. Your Honor.
you know, but just as important too, I think Mr. Odou has a valid point. He just says, what's the offer of proof?
I just want to know if it's something that I should be concerned about, or maybe I don't have a dog in this fight. I just don't know.
Joel, I don't think you do, so I will, we can meet with the parties away from here because it's after 5 and I know that this court wants to check it.
We're right here, let's have the offer of proof.
And I mean, because, I mean, it's tough, I mean, is she gonna talk about records, is she gonna talk about investigations, is she gonna talk about, I mean, testify regarding records? I mean, I don't know what, that's pretty broad as far as the designation's concerned. I get it, I can see why potentially, and here's my point, I don't know if anyone's being dilatory here, because I looked at the orders, right, I don't know. You agree with me?
I do, Your Honor. I agreed with you 10 minutes ago.
Okay. So, all I can say is, and so we can't give an, just generally, what's she gonna, is that, you know?
She's an application scientist. She works for Hanna Instruments in their applications department.
What is applications?
So, like Mr. Jason Brown, she deals with customer service. It's customer issues that come to Hanna. So she's going to be able to testify as to whether or not she has had any complaints with regard to the MW500 complaint from customers that, you know, this is not what it is. I'm sorry.
No, I was talking to Will, I wanted to address it, I don't want him to interrupt you, go ahead, so I wanted to address it after you're done, go ahead.
And so we think it's relevant with regard to what her experience has been with the MW500, if any at all, with regard to things, how they share the standard operating procedures between Romania and Hanna, as far as how applications are to be done, how things are looked at, because as Mr. Silvaggio testified about applications, each customer has different applications. In this case, we talked about a Congen system. Another one is this real water system. There are different ones and how that process is done. That's all she is. and how that works in the company, which Mr. Parker has talked to Mr. Silvaggio about. This is all one big company. Great, I get that. There's no reason why my client, who is Hanna, can't have their application person come on and say, this is how it's done for Hanna, since I'm being sued, in this case, as a distributor, as a part of the distribution chain for this particular product. And she'll be able to give that testimony. Do you need more than that for an offer of proof?
Well, Your Honor, if I could address what Mr. Rasmussen just said. What we've heard to this point is that the box is a Milwaukee box, so complaint can be directed to Milwaukee, not Hanna.
Maybe,
So
maybe not.
that's I waited for you.
You're right.
All right. And so now, after we learn what we've learned from Mr. Silvaggio's great testimony, I believe he wants to bring someone in there to say, Hanna never received any complaints. Well, customers were directed to Milwaukee. I don't see what place she would have in trying to address complaints went to Milwaukee. It's the only reason we address this with Mr. Silvaggio because he wears two hats, one for Hanna and Milwaukee. So I think his comments, Mr. Rasmussen's comments, are not well taken, and I don't think there's a reason to bring someone from Hanna to talk about complaints that Hanna never received through her. It may have been received through Milwaukee, but not, to our knowledge, through Hanna.
Where are these complaints, Your Honor? They haven't been produced or discovered.
And if there's something that she did and participated in pursuant to 16.1, it should have been produced. I will tell you, that's one of the reasons we asked about the motion to strike, because we believe that they never responded fully to the requirements of Special Master Hale. But we're not going to beat that horse anymore.
Okay.
So the trial by ambush has been gone away a long time.
I didn't try to ambush here. I put her in my witness list. I identified her in the 16.1 in one of the consolidated cases. I put her on my trial witness list. Her deposition was not taken. I don't know why.
But this is the only problem with that, Scott, that approach. 16.1 requires you to identify all your witnesses. We can all agree to that.
We did that.
If you, in the case, but this is the problem. If your position was correct, if we were to extend that logic to what I believe to be the most illogical end, that would mean that every production, 16.1 production we've done in every other case, we could call every witness from that case in this case if we just put them in our pretrial memo. That never works. Your pretrial memo has to have a relationship to the 16.1 disclosure you did in this case. And now that you've admitted you didn't do it in this case, I don't know how you can use your pretrial memo to bootstrap that witness in.
I see. So what you're saying is that Judge Alf's order must say that if you're going to use one in a particular case, when you do the 16.1, you have to abide by saying this is for the Gallagher case. Because Lord Brown will be our witness for all of the cases.
Well, that's what everyone else in this room did.
That's what I did.
No, we put Gallagher and our witnesses on our 16.1.
Well, the case.
That's what Real Water did.
And to be fair, in all the other disclosures, you disclosed Carl Silvaggio in every separate case. So we knew he was a witness, a disclosed witness in every separate case. We knew to take
We
his
believe
deposition.
she's in every other case that we've done a 16.1 disclosure.
But she wasn't in this one. So you're saying, I don't know why they didn't take the deposition. Well, we didn't take the deposition because she wasn't disclosed as a witness in this case. We're preparing it for trial, taking the depositions of the witnesses that were disclosed. She was disclosed in Henry, which Henry set for trial September 2024. We'll take her deposition in Henry. But to disclose her in Henry and then say, oh, should have taken a deposition in that case in preparation for this one and try to call her when she wasn't ever disclosed as a witness in this case is improper. And every single one of these cases, we have 16 separate cases, our firm does, 16 separate actions. They all have some of the same witnesses who are disclosed in every single one, and they all have independent witnesses. It would be like us saying, well, we're going to call a medical expert who's a treating physician in the Henry case because we disclosed that physician in Henry. That would be totally improper. It wouldn't be allowed, and it should be the same here with this Lord Brown case.
Okay. Let me see the Judge Alf's order.
Thank you.
Before I make a final decision. What did I say at the very beginning?
You wanted me to see all the orders before we decided, Your Honor.
16 minutes ago. Thank you, Your Honor.
Order 16 is now in session.
on the record.
All right, good morning.
Good morning, Your Honor.
Let's go ahead and set all our appearances for the record.
Your Honor, Will Kemp and Pepperman for Plaintiffs, Mr. Parker's in the next court order, should be here shortly, but we don't need for the jury instructions.
Good morning, Your Honor. Joel Dudek, Kaufman on behalf of Real Water Inc., Affinity Lifestyles.com, Real Water Gold Coast. Also present in court in the back are two law clerks from the Wood Smith firm, Nicole Farrell and Jaden Monica. Hopefully I didn't butcher that. Good morning.
Good morning, Your Honor, Scott Rasmussen, my planning on being the Hanna Instruments.
Good morning, Your Honor. Elizabeth Lowell and Rob Robbins. Rob Robbins is taking care of another matter. He will be here shortly for Milwaukee Instruments.
And good morning. All right, a couple issues. It's my understanding the panel member that went to the dentist this morning is not back yet. Right?
Right.
And as far as the update's concerned, I know the marshal stepped out. When he steps back in, I want him to give us an update, first and foremost, right? Secondly, what about the witness? What's going on there as far as the witness that's going to be called by the defense? Your witness. I mean, remember we had the discussion yesterday, we're going to bring in the orders, all that stuff.
We're still going to call her.
Okay, but aren't we going to bring in the orders for the review?
Yeah, I have the right here, Your Honor. Is that what you need? Yeah.
Yeah, that's
Right, approach.
correct. All right. Thank you, sir.
Your Honor. I did underline some of the areas. I have underlined them 3 times in this, and then I'll work through it. Some different parts of this, if you would like me to. We'll start with this particular order was entered on May 11th, 2021. Just so the record is clear, and I don't think it's disputed that at that particular time, Penn had not made an appearance in any of the cases. Okay. That being said, this stipulation first went to it in section 3 on page 2 with the following cases, and they're listed A through H. Neither Gallagher or the Henry case are noted, but they were adopted later. Okay? Then it comes to the language about what we would be dealing with. Starts in section 7. At line 16 on page 3, coordinating the real water cases for pre-trial discovery purposes will promote judicial efficiency and avoid both unnecessary costs and potential conflicting decisions on common issues. Coordinating or consolidating, section 8, coordinating or consolidating the real water cases at this time for anything more than pre-trial discovery purposes will not promote judicial economy or save or avoid costs. A joint trial with more than 40 individual plaintiffs is not practicable. And keeping the cases in their assigned judicial departments for the purpose of trial scheduling, trial-related, or other case-specific matters is more efficient and lessens the burden on any one judge. Number 9, line 24, page 3. The parties therefore agreed, this is the agreement, that the real water cases should be coordinated for pretrial discovery purposes only, and that the trial, as well as any trial-related or other case-specific matters, then it gives examples, amendments, dispositive motions, trial scheduling, motions to eliminate, should be heard by the separate judge assigned to each case. The other 2 sections, 10 and 11, I don't believe are applicable to what we're discussing today. The particular witness that we identified in the Henry case, which was adopted into the stipulation, is where she was identified. That particular pleadings, both the 3rd, 4th, 5th, 6th, all prior to the end of discovery in the Gallagher matter.
Now, when you say pleadings, what do you mean pleadings?
A 16.1 or the 16.1 supplement, like the 3rd amended 16.1 supplemental production of documents and witness list. The 4th supplement, excuse me.
Do we have
4th
those?
supplement.
Do we have a copy of that?
I did not bring those with me, Your Honor. Would you like those?
I mean, I thought that was part of the discussion yesterday, but go ahead.
I believe the court had asked me to make sure I brought down the order, and I did so, but
Well,
I don't think it's just,
But go ahead, go ahead.
I don't think it is disputed because both sides said they were in those particular supplemental productions under 16.1. Her name is there, it's identified. It is not also.
Here's my question, and understand this, I do see that for the purposes of litigation, consolidated cases for the purposes of discovery only can create issues. I'll leave it there, and then we'll dig a little deeper. But you're saying that the 16.1 supplemental disclosures in this specific case identified her as a witness?
The 16.1s that we filed with the caption in Henry are consolidated for all pre-trial discovery, pre-discovery purpose. Pre-trial discovery purposes. The parties have agreed that the real water cases should be coordinated for pre-trial discovery purposes only. And so that's the only language that we have with regard to this. Pursuant to that, all of the coordinated cases we did provide. Our office put them in the Henry case. Why? Because that was the first case that we answered in. That's the first case that we had to file an answer, and that's why we did that. It doesn't mean that the plaintiffs didn't get that. We all get pleadings for all of the cases.
So, I mean, I just want to make sure the record's clear.
Okay?
That this witness was identified in the Henry case, but when it came to the 16.1 supplementation in the Wren case, was this witness identified?
Our office only provided them in the Henry case. We have done that from the beginning. So all of our documents and everything else has always been identified in the Henry case as one of the coordinated cases, because that was the first case we believe that Hanna Instruments was first brought into in that case. And it is one of the coordinated cases.
So you been on it? Who's plaintiff's counsel?
Mr. Kemp and his law firm. I don't know if Mr. Parker is in the Henry case. To be honest.
Anything else?
No, the only thing I would say is that 16.1 is not mentioned in this order. Our 16.1s were identified, provided to all parties in all of the coordinated cases. And this witness was identified well before the discovery deadline, and then was described, was also in our pretrial memorandum and pretrial disclosures as a witness to be called at the time of trial.
Okay, sir, I understand. Thank you. Mr. Pepperman.
Your Honor, I'll start where Mr. Rasmussen finished with the coordination order. This coordination order does not say anywhere, nor can it be reasonably interpreted, that disclosures are only required in one of the, I think currently there are more than 20 cases that have been coordinated. Many of them involve us as counsel. We represent plaintiffs in, I believe, 16 of the actions, but there are plaintiffs in, I think the other, at least 6, 7, 8 that we're not involved in those cases. And so under Mr. Rasmussen's interpretation of this order, they could disclose a witness in a case that we're not even counsel on, and then call them in one of our cases because they disclosed them in another case. I appreciate, that coordinated cases like this can be complex and there can be confusion, but I think it's important to point out that none of the other parties in any of the other cases had any confusion about this. And I brought samples of the disclosures from us, from Real Water, and from UNFW, who we made 16.1 disclosures in every separate action. Now, some of them incorporated witnesses that were disclosed in other cases by reference. Some of them just repeated the same witnesses in addition to the case-specific witnesses. But that's not what Hanna did. They disclosed a witness in, I think it was about 60 days before the discovery deadline in the Gallagher case, when we were in the thick of expert disclosures and expert depositions, and where I think, over those last 60 days, we took maybe 40 depositions in total, if not more. And we never received a disclosure of this witness, that she was going to be a potential witness in the Gallagher case. We weren't looking at the Henry disclosures. This wasn't even done in the Lee Wren case. So we had no notice of this witness. There was no notice of this witness in a 16.1 disclosure in this case, to the extent that Hanna was confused about how to make a 16.1 disclosure in each case, which is, contrary to what every other party in these cases have done. That still doesn't change the fact that we were not given notice of this witness in this case. We did not have any opportunity to take her deposition because we didn't know she existed. And now they're trying to call her at trial without having any idea of what she intends to testify about. That was never disclosed. Without ever making a disclosure that in the 16.1 that would allow us the opportunity to inquire into what this person was going to testify about. I know, Your Honor, it goes back to the rules, and the rule's simple. You have to disclose a witness under 16.1. That obviously applies to the specific action, which regardless of coordination, this is a specific separate action. That disclosure was not made in this specific separate action, and that failure to disclose is not justified and is harmful because we were deprived of the opportunity.
Are we conducting Rule 37 B1 analysis now as it relates to substantial justification and or harmless? That's what I'm just asking the question, because that sounded like where you were going.
Your Honor, I'm just pointing out that there was a failure to disclose this witness in 16.1, and the rules provide you fail to disclose, you cannot call them at trial.
Anything else, Jim? Is that it? You want to add anything, Mr. Parker? Did you have a separate client?
Your Honor, let me just in part address the harm. When the name was...
Your Honor, I did forget to clarify, Mr. Parker is not in the Henry case.
I'm sorry, thank you. So, Your Honor, that would be the harm and prejudice. I certainly would never be aware of Ms. Brown, I guess, because I'm not in that case at this point. And so, for me preparing for it, I wouldn't know what to even prepare for it, because it was not produced in this case at all. And I don't think Mr. Rasmussen would dispute that. I've not signed in I've not substituted in for any particular plaintiff, and I've not associated in that case. So I had no knowledge of that witness, and probably the court gathered that when I asked Mr. Rasmussen more than once what her name was, so I could at least write it down. But I'm not familiar with that person at all. And certainly, given that I'm representing plaintiffs in this case,
Sorry, Your Honor. That's fine.
I shouldn't be obligated to check every other case filing to determine whether or not a witness or one of those other cases would be used in this trial. I mean, that's the quintessential trial by ambush, I would suggest.
All right, Mr. Rasmussen.
We did disclosure in the 16.1s that we filed, 16.1s in compliance with NRCP. It was disclosed in the coordinated cases. Her name appears starting in March of this year at the earliest. This is about 120 to 90 days, 120 days before the close of discovery. A simple phone call, is there anyone that's going to be out there that we didn't know about, things like this, but we disclosed her name. She's there. She's in the 16.1s. She suggested we can't use her Because there are a lot of parties, I don't want to, that did just in the Wren case, we only see them in the Wren. And we have to go on through there and match it all up. That's what our office had to do for several different defendants that are not necessarily in other cases like Gallagher or anyone else for that matter. But the reality is we did not do any 16.1s in this case because we were first named in the Henry case, which is one of the consolidated cases. And the order clearly states the parties therefore agree that the real water cases should be coordinated.
Page and paragraph.
I apologize. Page 3, section 9, line 24, the parties therefore agree that the real water cases should be coordinated for pre-trial discovery purposes only. And when it comes to trial, we did disclose her as well on our witness list. And I can't believe that we would be hearing that the plaintiffs in that case would not have received the pleadings in 16.1s that my client produced in the Henry case. They absolutely should have received those because they're counts formed. I agree, Mr. Parker is not in that, but that would suggest that he doesn't know what's going on with everything that Mr. Kemp's doing in this case. Obviously, they're together. In this case, it should have been able to figure that out as they are both at plaintiff's counsel table and know this thing. And that distinguishment, I think, is just not enough. But that's all I have to say, Your Honor.
I mean, I don't mind saying this. I'm trying to sit here and decide how to grapple with this problem, you know. And one of the issues, and I will say this, I never practiced under coordinated cases for the purposes of discovery and what impact that has on the underlying cases when a potential disclosure is made in the general sense, but not specifically the disclosures related to one of the underlying cases. I mean, that's really what it kind of comes down to.
One more item, Your Honor. If the court was to deny this, what will probably happen for all of the parties in every one of the cases, including my own, is that I will have to go back now and do 16.1s in every case so that the plaintiff is given notice of all the witnesses and all of the documents that I plan to do, which means I now have the burden, not coordinated, but to make sure I've got 16.1 amendments or supplements in every case for fear that a judge will say, well, it wasn't in my particular case that you do the 16.1, as opposed to I did do it in one of the coordinated cases. And the point is, as let me read the language.
I mean,
Part 7, coordinated real
I
water.
don't want to cut you off, so I'm a little bit more sophisticated than that. I don't mind saying that. I understand what the issue is, and that's why I'm sitting here discussing it with you, sir. You know, I do.
The paragraph 7 says, why is the purpose of coordination? On page 3, coordinating the real water case for pretrial discovery purpose will promote judicial efficiency and avoid both unnecessary costs and potential conflicting decisions on common issues. Like, is it 16.1 been done where I've disclosed this witness?
And how long is this witness going to be available? As long as I say she should be available?
Well, yes, she's a hand employee. If you need her to stay here, Your Honor, we'll figure it out.
All right. Go ahead, sir.
Your Honor, I would just add that the rules are clear.
I mean, I get it. I mean, and here's my point. I do understand what the rules say. I understand 16.1.
And Your Honor, I wasn't going to repeat that. I know you understand. I was just going to comment on the difference between coordination and consolidation. Consolidation is they're all made one single case with one single 16.1. Coordination, they're all separate cases. They're all individual cases. Mr. Rasmussen's comment that if you were to preclude this witness from testifying, that would mean that he has to go do 16.1 disclosures in every individual case. That's what is required. That's what every other party has done.
No.
Because it gives notice to the party in each specific case. These are the witnesses that I intend to call in this particular case. And yes, because they're coordinated, because there's overlapping facts, there's going to be similar witnesses in those. but there's also a lot that are totally different. So we need a disclosure to say, hey, these are my witnesses in this case. And if they want to refer us to another disclosure, so we can say, okay, all these witnesses, that's fine, but they didn't do that. If they wanted to state the witnesses again in this disclosure, so we know, okay, these are the witnesses you plan to call in this case, that's fine too. But they didn't do that. They disclosed them in some case that we didn't even look at. Because the trial's not until September 2024. Had no way to know that that witness was being disclosed in this Gallagher case because there was no separate 16.1 disclosure. And then saying, oh, well, we disclosed in this other case that you would have no reason to look at because trial's, like more than a year away, a year and a half away at this point in time. And so now we get to ambush you with that person. Mr. Rasmussen hit onto something, is taking this to its logical conclusion and the impacts of your decision. If you're allowed this to happen, if Mr. Rasmussen's allowed to disclose a witness in some random case that's not set for trial for a year and a half because it's coordinated with this case, then that would mean any plaintiff or any party could selectively and strategically disclose witnesses in other cases that are not even being looked at, or maybe even don't even involve the same plaintiff's attorneys, and then bring them at trial and say, surprise, we disclosed them in this other case that is coordinated. That would be the real prejudicial impact. And I just want to emphasize one more time. Every single party disclosed their witnesses in each individual case. That's not been confused. No one else has been confused or unclear about that. And we relied on that for assuming the witnesses that they were going to call at trial. So it would be, it's a plain violation of the rule, and it would be extremely prejudicial to allow this witness to be called on, as Mr. Parker said, a quintessential trial ambush.
Mr. Odou, sir.
Thank you, relative to real water. I don't necessarily have a dog in this fight, but I want the record to be clear. The way the document repository is set up is not the way either of them just described it. Unfortunately, the document repository, if you're looking for something from Murchison and Cummings, you go in their directory, and all of their disclosures are in the directory under the law firm. It's true that the notice of compliance would be served in Henry, but then to find it at Hollow, which is the document repository, you go to their firm and then you find all their disclosures. I think that's important for the court to know. There has been some confusion on this. We had a discussion between Real Water and UNFW. We then started doing it one way, but in looking at the other disclosures, I do believe there is some confusion out there, and it's a pretty severe remedy to exclude this witness. I think it's a special master issue and it's not ideal. Again, I don't really have a dog in this fight, but I want the record to be clear because I think this is going to come up in other cases.
Finally, I just want to make sure you understand that my client is named in all of the coordinated cases. So again, I would, different than other defendants, because not some of the distributor defendants that we've had, like UNFW, is not named in some of the other cases. And so I see that they would not do a disclosure in a case that they're not named as a defendant. Now, what this would do is I'm going to have to put it out for every one of them, and I hope I'm not late on cases like coming up in January on Hunsworth, and making sure that everyone's in it, but I'm gonna have to do this, I think, 27 times. And the purpose of coordination is to promote these things. And all of my disclosures, Mr. Odou just told you, at Holo, they're all there under Murchison and Cummings. No one else represents Hanna than my firm.
All right. Is there confusion there as far as the process is concerned?
There wasn't any confusion on our part, we did it right. There wasn't any confusion on Real Water's part, they did it right. And there wasn't any confusion on UNFI's part, they did it right. Apparently now, the last day of trial, we find there's confusion on Hanna's part. Your Honor, this is just so prejudicial. I mean, I took all the Milwaukee witnesses that were disclosed. I took their depositions. I took Mr. Silvaggio. I took Jason.
And Mr. Kemp, I mean, for the record, this witness wouldn't testify without their deposition being taken.
And now we're supposed to take a deposition when we're trying to prepare for closing arguments, Your Honor? I mean, what kind of burden is that? Because he made a mistake, you know, and then this suggestion that Mr. Parker, who's not even in this case, should have to root through all the directories of, I don't know, there's 20 different cases, 27, whatever. You know, I mean, that just turned into 61 on, it's meaningless, you know? All he had to do was file the disclosure in this case like everybody else did. That's all he had to do, Your Honor. And, you know, he says, well, you should call me and see who my witnesses are. Well, I don't have to call him, that's the whole purpose.
I understand that, nobody calls.
Yeah, and then maybe I depose all the witnesses, but not this one. Maybe a light bulb should go on in his mind that I've done something wrong, I haven't disclosed this one properly. You know, instead it's, here's the secret witness that no one knows what she's gonna say. That's gonna be sprung on us at the last minute. So I think it's pretty crystal clear what they should have done. And if they didn't know what to do, and they saw everybody else doing it right, why didn't they bring that up at the special master hearing? Why didn't they call Mr. Odou and say, hey, why are you doing this in the Gallagher case instead of just relying on, you know, the plaintiffs having to root through all these files and find it? You know, it's just not fair to the plaintiffs, Your Honor. Here we have, I don't know, I have no idea what this person's going to say, but it must be important because they're fighting for it. And if it is important, it's something that we could have addressed either by hiring experts, we could have addressed it during the conduct of the trial, but to come in, you know, a day or two before we're doing the closings and say we get this secret surprise witness that wasn't disclosed, there's no way to fix that. There is no way to fix that, Your Honor.
Mr. Park, you want to add anything now?
Yeah, the only other thing I would add, Your Honor.
Rasmussen is the last word.
Thank you. Your Honor, the only thing I would offer is that not knowing exactly what this witness is going to testify to would have also prevented us from doing motions in limine in terms of her testimony. That has been completely been taken away from us, that opportunity.
Mr. Parker, I get that. That's why I said at a very baseline, the witness couldn't testify without the deposition being taken.
And I appreciate that, Your Honor. The problem is we've done openings, we've closed our case in chief, and that deposition could affect how we would have handled our opening in our case in chief. That's the problem, and we don't know how it's going to affect the testimony of the witnesses that have already come before. That, when I think of the harm to my clients, given that I'm not aware of, I guess what Mr. Rasmussen is saying effectively is, Mr. Parker, you have to go check every case that you're not involved in to determine which witness I'm going to bring in my case. That's not appropriate, Your Honor. I shouldn't have to check cases that Mr. Eglet's firm is involved in, or Mr. Colby Williams' cases a firm is involved in, or the other 16 cases that Mr. Kemp's office is involved in. I have a few cases that I'm working on with Mr. Kemp at this point, and it's hard enough keeping up with the three or four that I'm working on with him. To have to check the other 16 and every other case for the other 70 plus plaintiffs in this real water issue places an unreasonable and unexpected burden on my firm. And certainly when I'm preparing for trial, and I don't mind calling Mr. Rasmussen or Mr. Robbins to find out who they're going to call on a particular day, because we've been doing that. But I can tell you, it wasn't until just the last couple of days that this name came up. And as soon as it did, we wanted to make sure the court was aware that we were unfamiliar with this name. And like I said, I don't have a single document in my office that reflects her name, because I'm not in any of the other cases where they may have identified. So I don't know how Mr. Rasmussen would suggest reconciling the extreme prejudice to my clients versus the significant prejudice to the other plaintiffs in this case who would not have been aware of this witness. I think it's irreconcilable, as a matter of fact, Your Honor. And certainly under Rule 37C, the plain language of 37C says if you don't produce a document, it's not allowed. If you don't produce a witness, identify a witness, it's not allowed. And I hate to bring up what the Sunrise case says about not identifying witnesses. That's even a harsher penalty. And so I'll leave it at there, right there, Your Honor.
Okay. Mr. Rasmussen, get the last, I missed Odou, anything you want to add, sir?
No, you didn't. Witness in question was identified in
I'm not sure.
in this case as a part of our
But that's my
pretrial
last one.
witnesses and exhibits.
I'll print one more for you.
In this case, I want to say back in July. And so the plaintiffs have been in notice at least since then. They didn't object then, they didn't bring this to the court then. The plaintiffs' counsel, Mr. Kemp, has had our 16.1 disclosures since March during discovery. And all of them that have been under our name, and that's what I can tell you. So now to say it was today or yesterday for the first time, we don't want this person called, when this should have been brought up back in July when we did our pretrial memorandums, then we could have dealt with it then and said, objection to this witness, and instead they're objecting to it now after they've rested. I don't know why, but it seems that to be complaining about something at this late date is also prejudicial to my client. That's all.
And I just have one last question for you. You said pursuant to the 16.1 disclosure, this witness was identified.
In the pretrial memorandums in the Gallagher matter, she was disclosed. In the 16.1s, she was disclosed, yes, in the coordinated cases, specifically the Henry case, which is one of the coordinated cases. The order on this, which we provided to the court, this is what it says. And we have put all of ours into that particular case, and then so that no one's confused as to what we are going to do with our witnesses, who they are, and who are the, and by the way, they use those to find all of the other witnesses, Mr. Silvaggio, Mr. Petrian, everybody. Mr. Dupree, Mr. Shannon, all these people were found, all of these witnesses' depositions were taken. I don't know why they didn't do this. Okay, there were prior people that they asked Mr. Silvaggio that are not here, other people that they found and asked questions about.
Well, the reason we didn't depose her is they didn't identify them in the interrogatory answers that were served upon them. That's what we teed off on. And I didn't bring the set. I looked at them last night to see if this woman's name was in it. It is not in those interrogatory answers. I will submit them to the court at lunch. But you know, that's another problem, Your Honor. I mean, so to say that I should be clairvoyant, you know, that they don't tell me who the witnesses are, take all the others, and all of a sudden there's this secret witness pop up. I mean, that's just not appropriate, Your Honor.
Your Honor, you raised one other point, and maybe Mr. Rasmussen is correct. This is not an argument, it's just a question really. And I'm just checking, I'm reading from my notes. On September 22nd, which was last Friday, I asked each of the defendants who their witnesses would be.
The next day.
Joel told me Brett Jones, potentially Mr. Neslin, Blaine Jones, and he said he may have a reader. That's what I was told. Scott Rasmussen told me Carl Silvaggio in person, John Babcock, or Jason Babcock in person, David Fontenbach in person, Tim Shannon, Devil Reed he said maybe Adrian Petrian and Casey Aiken, Volume 2 Depot. That's what he said. Friday, so again, I take notes of all these conversations. Friday at roughly 1:10 in the afternoon, I asked the same question. Mr. Rasmussen tells me Carl Silvaggio, Casey Aiken, David Fontenbach, Jason Babcock, and Tim Shannon. It wasn't until Tuesday that Laura Brown came up, and that's when we raised the issue and this conversation ensues. The point is, we have been participating, I thought, cooperatively towards identifying our witnesses. He decides on Tuesday, we react to that, Your Honor, and that reaction is genuine because I certainly was never aware of Mr. or Miss Brown. And so I just wanted to point that out for the record, how we've been trying to keep on top of each other's witnesses, and Laura Brown was not ever identified until yesterday.
And your final response to that, sir?
You know, I fear that I'll probably do a final response, I'll just, even though it's my final response, that they'll just add something more, so I'm done.
Okay. And as far as the interrogatories are concerned, what was the call of the question?
We're having them simmed down, Your Honor, but they were basically standard interrogatories, who's involved in this area company, who's involved in that, who's involved in the other. But we'll have it sent and I'll submit it to the court. Then we can answer it.
I have so many interrogatories here, but just because I keep stuff. Your Honor, there, and I don't, Mr. Rasmussen can address this, but I have Hanna Instruments' first supplemental answer to plaintiff's first set of interrogatories. The names identified are Michael Dupree and Carl Silvaggio. Other than those names, at least in terms of the supplemental, Adrian Petrian is also identified. And that's the only names. Company names are identified, but no other individual names are identified in the supplemental.
I propose all three of those people, Your Honor, Silvaggio, Patriot, and Mr. Dupree.
What was the question again, Mr. Parker, with the interrogatory?
Well, the one that identified Carl Silvaggio and Michael Dupree, it's interrogatory number 1. The question is, state the name, current address, and telephone number of each person who, to your knowledge, information, or belief, was involved in the design of the subject meter. Her name is not named. So in terms of applications, she's some kind of application specialist. If it dealt with design, she should have been identified, and she's not in this answer. And then the other, and I will also indicate that this interrogatory number 2 speaks about the date of manufacture. They identified several companies. Interrogatory number 3 says state the name, last job title, current address, and telephone number of all persons employed by the factory where the subject meter was manufactured. That response does not include any names. In fact, it says the plant where the subject matter, after the objection, of course, the plant where the subject meter was manufactured is owned and operated by Hanna Instruments S.R.L., a separate Romanian company. As such, Hanna Instruments is not in possession of the information. The defendant reserves the right to supplement this answer should additional information become available. By the way, these answers were provided December 29, 2022, Your Honor, just to put it in context in terms of the date. And then Adrian Petrian's name is identified as a supplemental response to interrogatory number 7. Interrogatory number 7 says identify the individuals and defendant who were responsible for quality control and inspection of the subject meter, and Adrian Petrian was identified. So I would have expected that Laura Brown dealt with this meter, she would have been identified at least 2 of these interrogatories, and she's not. And if the court would like me to make this this document an exhibit to the record of this topic, you know, I can have a copy made.
Are those the same interrogatories, Mr. Kemp?
Yes, Your Honor. There's also Milwaukee interrogatories that don't disclose this witness. It is a Milwaukee meeting.
Yeah, it's not my witness.
We're not incriminating you,
All right,
Mr. Robbins.
just so we're clear.
Okay, can you show that to Mr. Rasmussen?
I don't need to,
You know where it is?
I know where it's at, and I agree that what you read to you is true.
Okay, because I want to see it, and we'll make it.
Can you make it that, this is the redacted version, so we took the insurance references out of this one, Your Honor, just because I intend to use it for trial.
Are there any notes on it?
No, I have not put any notes on it. Well, I've highlighted. I'll get you a clean copy without my
Give
highlights.
me a clean copy so I can.
Can you print one out for me? Exhibit 757.
Yep.
Have we heard from the jury yet, sir?
Yes, we have all, with the exception of the one juror, Your Honor, for aforementioned reasons, and if I may approach, Your Honor.
Yeah, you can.
Yeah, I know, because, you know,
We can go off the record.
Thank you, Honor.
Let's go back on the record.
Your Honor, I just want to make sure you know, after Rob Robbins came up to the bench, we did realize that our expert also has availability, and he is speaking with our expert now.
Okay, I understand, ma'am, thank you.
So,
Are we on the record now?
Yes,
Okay.
Your Honor, Scott Rasmussen, that's okay, and Cardi said that's okay for me to speak. We have contacted both of our experts, and I was able to do that. One of my experts does not have a problem being able to be here the rest of the week, and even into next week if that's what happens with regard to this juror. The other one can be here today, which we were planning on doing, can be here tomorrow, can't be here Friday, can be here Monday. So I
We're
can't.
fine.
Let's do it tomorrow.
Yeah, we're fine.
I needed to call and make sure, that's what I did.
Yeah, no, that's good news, we're fine.
I'm just trying to, you asked me to go out and call me those phone calls, that's why I'm reporting.
Thank you.
Thank you, sir. Screaming at me, no matter what.
So that's just.
I don't raise my voice, good.
So tomorrow we're gonna finish Silvaggio, right?
Okay.
You have to interrupt that, or whatever you want to do, I don't care, I just want to know.
No, I don't have. The only other one is Laura Brown, the decision, hopefully, because,
Oh, we'll make a decision on it.
thank you, that would be important to know.
Yeah, I understand.
So tomorrow we do potentially Silvaggio.
And we'll should finish up then we'll do the 3 videos, but because I've got the one time check with David Fortenbaugh, that's the one that cannot be here on Friday.
He can be tomorrow.
He can be here tomorrow. We'll make sure that Dr. Fortenbaugh comes on tomorrow.
Okay.
Even if at the, we'll make sure that happens, right? The court will make sure that happens for me, please.
Yeah, Judge, and if they have a problem, maybe move Heidel up, you know, I have no problem keeping someone's case in chief open to let someone else bring an expert.
And then Jason Babcock can go on Friday, assuming that we have to take that time, okay?
there's also an issue as to, I'm not sure whether Anthony Brown is testifying by deposition video.
Yeah, we agreed to do it by deposition with.
Yeah, we agreed to
So they've
deposition.
already given us page lines on that.
Okay.
Oh, we're missing some.
No, I didn't get the page lines for Anthony Brown, but I can get those on the break. That doesn't need to be just on the record. I'm sorry.
I said, yeah, we do have them right there.
What's that?
We have page lines on Brown yet?
Anthony Brown?
Okay.
I just received them this morning,
We
so,
just got them this morning, man.
Okay.
but if we have them today, I just have the Blaine personal depot to go through and the Anthony Brown one, we can hammer those
Like
out.
Casey Aiken?
Casey Aiken, we hammered out
It's-
yesterday.
Okay.
Well, it's done with objections.
There's a couple of objections to
So
me.
he needs, that is before the court?
Yeah, we can do that today if you want.
Okay.
Mr. Marshall, can you check with Ms. Berkheimer as far as the adjustment of the calendar and whether 10 o'clock will be a good start time tomorrow?
Yes, Your Honor. I'll come back with the results.
Because we just need to know.
Yes, Your Honor.
As much as I'd like to, if there could be a break at some point, I'd like to just go to the bathroom real fast.
Go right now. Go off the record. Anyone that has to go to the men's room or ladies' room is skipped.
Please be seated.
All right, did the parties stipulate to the presence of the jury?
With the exception of one seat.
Yes.
Yes, Your Honor.
All right. Ladies and gentlemen, I want to say good morning to you.
Good morning.
All right, and we do have one issue. I won't call it a problem because we can always remedy problems, right? But as you probably are somewhat aware, she's not here, right? And she had, she had to go have some procedures done. And we've been in contact with her. And she's, she's just like all of you, she's put a lot of time in as far as, the trial's concerned, coming down every day, going through the whole processes. And so she doesn't want us to continue without her. I can't blame her for that, right? And so what we're gonna do is this, and this makes sense. She said, I think our last communication regarding tomorrow is what time, right? And so we want to make sure that she has an opportunity to participate, and she's participated all up until this point. She just had a health issue, as you know, and but she's ready, willing, and able to start tomorrow at 10 o'clock, right? And so that's what we're going to do. I apologize for what happened, but that's not, within any of our control. We just try to accommodate those types of issues because things do happen as far as life's concerned. But here's one positive, and at some point, I do have to work with counsel, and we spent time with them. I think it was last week, working on jury instructions and like, we didn't complete it, but we're gonna complete all that today. And that's something we have to do outside your presence anyway. And sometimes what happens in cases, it depends on the trial, but sometimes the jury's waiting around, waiting for the lawyers to finish instructions. You don't have to worry about that. We're not gonna put you through that. We try to manage it a little better. So with that in mind, and understand plaintiff's case and chief's done, I guess we're gonna start with Mr. Silvaggio's, the finalization of his cross-examination. And there might be more questions from other, or Mr. Rasmussen might wanna ask some questions after Mr. Parker's done. And then I think we're gonna have a couple more witnesses, is that correct? It's my understanding Mr. Robbins will have one of his experts testify tomorrow.
Yeah, I have. My anticipation is depending on what Hanna puts in, that I would end up with one component by video and one live expert.
Yeah, and ladies and gentlemen, understand that sometimes just because of convenience and just timing, we do call witnesses out of order just because of availability. And but when we call a witness, we identify who the witness is testifying on behalf of, just so you understand. And so it's my understanding one of Mr. Robbins' witnesses is going to testify live. He's only available tomorrow. Is that correct, sir?
Say again?
He's only available tomorrow.
He's only available tomorrow in the morning.
Right, and that's why he's going to testify. Right. And remember this, a lot of the witnesses have come in from out of state. Right, and I know you understand that. So anyway, what we're going to do is this. I'm going to go ahead and read the admonishment, and then tomorrow I'll be ready to go at 10 o'clock.
Thursday.
Right, and that's what we'll do. So ladies and gentlemen, you're admonished not to converse amongst yourselves or with anyone else on any subject connected with this trial, or to read, watch, or listen to any report or commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibition there. And last but not least, do not form or express any opinion on any subject connected with this trial until the cause is finally submitted to you. Okay, Mr. Marshall, sir.
Yes, Your Honor. All rise to the court jury.
10 o'clock.
Jury is clear. Please be seated. Thank you.
Thank you. Okay, let's continue on. And I know there are issues brought up regarding the potential claim examiner. That's where we left off with the jury.
Yes, Sean, we just haven't heard back to figure out who she works for, if there was any contact with the jury, anything like that, Sean.
We don't even know her name.
Anyone else? Well, I think one thing we can do, one thing that can happen after jury verdict, we can find out whether she had contact with the jury. Right?
That's correct.
We'll find that out. Just don't, make sure you remember that.
Yes, Your Honor.
So where do we go next?
Judge, I thought it might be a good idea to take a quick look at the verdict form, because I anticipate we're going to be spending a lot of time on it. And I don't think we're going to resolve any big issues on it. There may be a couple small issues that can be resolved. And so, I mean, the philosophy behind the verdict form is, well, we're trying, do you have a copy of it, your own file?
I don't think so.
Your Honor, just so you know, Mr. Kemp was involved in those discussions, and I apologize for interrupting. But the parties met with Mr. Pepperman before this, and if we were going to lunch at noon today, in 10 minutes, we could get about 10 different jury instructions that are agreed upon and provide those to the court right now. And then we can work on the
I
verdict
don't have a
form.
problem with that, they got the verdict form right.
That's what I thought might be better.
As it would do. Because I don't mind telling you this, when there's common ground, I want to make sure.
Well, that way it's done, it's in the record, and we're finished with that, and then we can all grab a bite and make sure that your staff gets on normal time. That's what I thought. So, Mr. Pepperman, you can certainly explain to the court which ones we've agreed upon.
And this is a continuation, is that correct?
Yes, so when we were discussing this on Monday, we provided you copies of plaintiff's proposed jury instructions, which is what we were working off of, and then there were some from Hanna and Realwater as well.
Okay?
Your Honor, I think for our purposes that we could go through quickly, we would direct your attention to page 35 of plaintiff's proposed jury instructions.
Yes, sir.
And this was sort of brought up, and we still need to meet and confer on the jury instruction on how we handle Realwater's admitted liability and Hanna and Milwaukee's contested liability. But I think for our purposes, for this instruction, we agree that the first sentence where it includes defendant Realwater's admitted liability, we're still discussing that, but starting the second sentence and determining the amount of losses, I think we have a general agreement on a modified version of the stock to use that language to instruct the jury on the introductory instruction on personal injury damages.
With regard to sentence number 1, I'm fine with that. So did I cut you off?
No, either way, it's fine. Go ahead.
Sentence number 1 says, defendant Realwater has admitted that it manufactured and sold the defective product, Realwater. And I think it needs to say something like Realwater bottled water products, because it didn't quote manufacture real water. It manufactured bottled water. Follow what I'm saying?
Well, we can address that.
But that's what it is.
I don't think there's any
There's no dispute.
dispute on the need, it's just the language, which I think we can address, but at least for this instruction, starting with in determining the amount of losses suffered, this is just a modified version of the stock instruction, and it's modified based on the first line, and then
An additional line.
the last line says the items listed in the following 2 instructions.
And that's a fair summary, Your Honor. I think,
Here's my question, and I don't mind telling you this, whatever you agree to is fine. But when I read the proposed jury instruction, then I circle back to, and this is what I think is missing. And this is 10.01, and that's what appears to be what this instruction is potentially based upon. And that's the admitted liability instruction that's set forth in the 1986 book. And for example, in the book it says, the defendant has admitted liability for plaintiff's personal injury, right? And my point is this, the instruction should be simple and clear. And so it doesn't really say that clearly. Maybe it should say defendant Realwater has admitted liability and that it manufactured, manufactured and sold a defective product, Realwater, and that its defective product was a legal cause of plaintiff's injuries, period. Something like that. Or it could be admitted responsibility And the only reason I bring that up to alleviate confusion.
I think we're very close on that, Your Honor. I think the issue that's still being determined is how the other defendants would fit into this instruction, if at all. And that's where I think the whole record is.
Yeah, because if you look at 10.00, you have the introductory instruction that says, you know, in determining the amount of losses, if any, and then you have the admitted liability, that's just liability, not causation. And so we don't really fit into really either of those because we have two defendants who haven't admitted any liability at all, and we have the other one who's admitted liability and causation. So I think it's just figuring out a way to discuss it, and you know, I don't think there's any dispute over those facts. It's just determining the best way to state it. I think probably Real Water proposed a separate jury instruction on this, which, you know, that may be the ultimate way to handle it. And if it is, then I think for this one, we would just go into determining the amount of damages. So I mean, maybe we should just put off this one until we can discuss it further before we come to any conclusion. I guess the point, more to the point, is however we handle it, it's going to say that, you know, you need to decide upon a sum of money sufficient to reasonably and fairly compensate each plaintiff for the items listed in the following two instructions. And then we would go into the stock damages instruction.
I mean, that's the standard language from the last paragraph in the Nevada Panel Jury Instruction 10.01, right?
That's right.
So that's fine. We want to work out that, it's like as we discussed sidebar. Mr. Odou, if you would, I'd rather have you work it out.
Thank you.
And if we can't work it out, then I'll make a call.
The next instruction on page 36 is a jury instruction 10.02 modified. This is the stock instruction. In this case, we have all the past medical damages established on summary judgment. And then the future damages are contingent. Right now, we don't have a stipulation on the amounts of future damages. So how we have the jury instruction is that the court has already determined the past medical expenses incurred by each plaintiff as a result of his or her injuries. You are to determine the medical expenses, if any, that you believe that each plaintiff is reasonably certain to incur in the future as a result of his or her injuries. There was a comment when we were discussing that to say you are only to determine, or you need only determine. We're fine with those, you know, characterizations. And again, this is contingent. If we reach a stipulation, we'd have no need for this instruction.
And so, well, I just want to make sure. Okay. So you're saying, well, potentially the language should be modified. You are only to determine?
I think you need only determine.
Okay.
And Your Honor, the hiccup on this one is this ties into what's going to be on the jury verdict form, and so we may have to come back and readdress this later. But that's the current hiccup.
Which is why I wanted to start with the verdict form, because I saw that hiccup. Go ahead.
Yeah, there's no, on the verdict form now, because we were discussing a potential stipulation, we didn't include a line item for future medical damages, but obviously, you know, that's an easy modification if need be.
So now we're at the 10.04 modified, right?
So the next one is 10.04, and I was wrong, I double checked, I put modified, but this one is the stock during instruction, I believe.
Hanna agrees to 10.04 unmodified, as Mr. Pepperman just described.
And Real Water is agreed.
Oh, I think I might have put modified because I made sure it's endured by each plaintiff instead of the plaintiff.
Oh, okay.
And that's how it should be.
This one's otherwise agreed to. Next, page 38 is jury instruction 10.05. This is the pain and suffering, no definite standard, the stock and agreed to.
No objection by Hanna.
Yeah, we don't have an objection to this one.
Page 39 is jury instruction 10.12, modified only to identify the heirs by name and to say that, you know, it's not contingent on finding liability.
We're fine with that. Of course, we're going to have to modify it to say that we're still contesting liability, but we'll work that out.
That's a separate instruction. It doesn't really affect the damages instruction.
Milwaukee would agree with Hannah's reservation.
And Real Water agrees.
Judge.
I'm trying to figure out where we're going on that because I don't want any confusion. What are we agreeing or disagreeing to?
So here's the issue, Your Honor. The Real Water has admitted liability and causation, so the jury has to be instructed to, they're determining these damages, regardless of Milwaukee and Hanna's liability. If Milwaukee and Hanna are found liable, then they're responsible for the damages. If they're found not liable, then they aren't responsible for the damages. But either way, it doesn't change the damages instruction. The jury needs to be instructed that they need to determine the amount of damages to each heir. This is the introductory instruction. It says these are the heirs, and you need to determine the amounts of losses suffered by each of them for the items listed in the following two instructions. That's true whether or not Hanna and Milwaukee are liable, and to start adding in stuff that says, oh, if Milwaukee and Hanna are liable, you don't need to consider these damages, it's not correct, and it's just confusing.
We've been using this instruction for 40 years.
So it's not the instruction, Your Honor, so much as that the court hasn't, as far as I can tell from what's been ruled as before, is that we are necessarily jointly liable with Real Water for each and every separate category of damage. They're taking on liability all of a sudden, as I recall, during the motions hearings and near the end where they admitted liability, that medical specialists, for instance, were just kind of taken off the table with regard to our clients.
And we filed a motion for summary judgment on that.
So I don't know what the motion for summary judgment said with regard to we are now responsible for their medical bills. As a matter of summary judgment, we are.
No, they're not responsible for the medical bills unless the jury finds them liable. But that's a separate instruction. These are the claims against Milwaukee and Hanna. These are the elements they have to approve. And the verdict form says, do you find Milwaukee liable? Do you find for the two different theories? So if they say yes, then Milwaukee's responsible for the damages, and Milwaukee and Hanna. If they say no,
they're not.
they're not.
Is that how we're looking at this? Okay.
Well, but you understand, they're like interrogatories, special interrogatories as they go through for each defendant. You have to have that in the verdict, right? And so just because you're given this instruction, this doesn't stand for the proposition that you automatically determine vis-a-vis wrongful death that your client's responsible for the injuries. This is not what it says.
Correct.
This is just a snapshot as to what the jury has to consider when it comes to determining the amounts of losses suffered by the heirs.
Understood.
That's all it is, nothing more, nothing less. So anyway, do we have objection? I mean, and understand this, I'm not forcing anyone to agree. If you have an objection as far as this proposed instruction based upon Nevada pattern jury instruction 10.12, that's okay. You can object.
No, I just wanted to hear from the court as to whether or not the admitted liability is also, and like I said, I could be wrong on this, and that's fine. I've been wrong many times in front of this court. The medical specials in this case, and I'm just talking about medical specials for right now, is now something that is the damages, and that all of the defendants, if all of us were to be found liable, will also be responsible for medical specials, future medical specials, in this case, and pain and suffering.
Well, my question is this, and it's my understanding, a motion for partial summary judgment was filed as it pertained to the medical specials incurred by the plaintiffs in this case, right?
I believe that's what Mr. Kemp said.
Yeah, I mean, that's what happened, right? Didn't that happen?
Yes, Your Honor.
And it was granted.
Okay.
So my point is this. There's a difference between reasonableness and necessity of medical expenses as a result of a tort case versus liability.
Correct, Your Honor.
Yeah, I mean, it's a different issue.
Thank you, Your Honor.
So that doesn't mean your client's automatically responsible based upon this instruction.
Okay.
So as far as page 39, or I guess, Nevada pattern jury instruction 10.12, modified to get that. All right. We'll move on. Next up, I guess, would be based upon Nevada pattern jury instruction 10.13. Is that correct?
Correct, Your Honor. This is the stock instruction. My understanding is defendants have an objection to some of the language regarding financial support.
That is correct, Your Honor. Your Honor, there's no dispute that the decedent shared a living arrangement with one of the heirs. The issue is just quantifying that. And this instruction, some of these parts, particularly 5, 6, and 7, there's no evidence of that. Ms. Ryerson was retired, so that takes care of number 6. And we don't have evidence as to, income received from some other source. 5 is kind of the same problem as 6. And then if 4 is not an issue, but then 5, 6, 5, right? And 7 is not, we don't have much evidence of that the jury could rely on. So our proposal would be go 1 through 4 and 8.
Hannah agrees with that.
Milwaukee would also object based on what Mr. Odou has articulated.
Mr. Pepperman.
I mean, the evidence is the evidence. She was retired. She wasn't destitute. She, contributed small amounts to bills in the home. We're not talking about a lot of money, so I not overly concerned with it. But I mean, I think you're talking about a lot of more modification than just kitting out the couple of 5, 6, and 7. I think you'd have to say the heirs loss of probable support, companionship, society, comfort, and consortium. In determining that loss, you may consider, and then just list the 1 through 4 and 8. I mean, I'd be fine with that.
So what you're saying, you have no problem with 5 and 6 going? 5, 6, and 7?
No.
For example, what would be the basis for loss of probable support between sisters?
Well, the testimony was that they were sharing an apartment and that she was any part of the rate that she could.
Right.
That's all it was. Which I think is why Mr. Pepperman said we don't feel strongly about it, Your Honor. It was not a big-
I understand,
Yeah.
but my question was, what's the basis for it?
That's it.
Yeah.
And Your Honor, I think that belongs in number 4. The decedent was kindly affectionate and took care of her sister. So it's not like they're losing the argument. They still have that argument. There's just no way to quantify the numbers.
And Your Honor, I'm not, like I said, this isn't a hill to die on, but the instruction is more than 5, 6, and 7. It says right off, in determining that loss, you may consider the financial support, if any, which the heir would have received from the deceased except for her death, and the right to receive support, if any, which the heir has lost by reason of her death. I mean, it's saying if any, so I think really this is just the stock, and there's just none, or a minimal amount, but I'm fine if they want to strike it.
Is there a damage calculation for that?
No, Your Honor.
Right? Okay.
Yeah, I just think we need to exclude everything about financial support if that's, what is preferred.
If we're taking out 5, 6, and 7, we should take out the reference at the beginning.
Okay.
That's fine.
That's fine.
Well, yeah, I understand, you don't want to create confusion.
Right.
Correct.
I get it, I get it. So, we'll make sure. Determining.
So everything after and determining that loss, you may consider, everything after that until the numbers would be stricken. And then we would just list 1 through 4 and 8. Is that agreeable?
Yeah.
Yes.
And we try to tighten that down a little better in the verdict form by listing specific critical items. So we try to help out that point.
Funny, it always is. Nothing is.
All right.
No, that's okay, we're agreeable to, I'm just pointing it out, nothing's quite.
I was hoping.
But we're getting it done. Okay, we move on to the next.
The next one is page 42, pattern jury instruction 10.15, wrongful death, heir as a plaintiff, grief or sorrow.
No
That's
objection.
The stock, no objection.
No objection from Milwaukee.
Yeah, that's going just to the future.
The next one, page 43, is an instruction regarding life expectancy. That's not in the 1986 stock version, but I added this from, I think I got it from a prior case that we did. It's based on the life expectancy tables that we had pre-admitted as evidence, which show an average, the life expectancy of I think it's actually a female person, age 69 is 16 years.
We have no objection.
Objection.
No objection from Milwaukee.
It's funny, when you're younger, you don't pay much attention to life expectancy tables. But as you get older, you start paying, right?
Your Honor, the instruction makes clear, that's just the statistics, okay?
Yeah, I
Give it below
understand,
You pay attention to a lot of different things when you're older than us.
but, yeah, you do, I mean, as a 35-year-old lawyer, I would have never paid attention.
The next one is page 44. It's jury instruction 10.16. Just modified to reference the decedent, the pain, suffering, and disfigurement experienced by the decedent, Kathy Ryerson.
And the objection that we had to, the real water had to this one was the disfigurement. This isn't a disfigurement case. We understand that there were certain adverse effects of hydrazine toxicity, including the swelling and all of the other medical damages, but we think that's covered under the pain and suffering. It's really the same issue in the one that follows this, and so I just don't think it's been that belongs.
Judge, should we put that picture back up of the scene in the hospital?
I'm sure we'll see it before we. Anything from anyone else?
I'm looking at the stock language and just seeing that a couple of the sentences that are in there are not included. I'm not sure why. I'm not saying that they necessarily have to be there, but.
Are you looking at 1016? So I just want to make sure so I know.
Yes, Your Honor, I apologize. 10.16, it's been modified, I understand that, but it starts out with, if under the court's instructions you find that one or more of the errors, which I think we have more than one error, is entitled to a verdict, you must also award such error and then, or errors, as damages. And I don't have a problem with the word Kathy Ryerson. I agree with Mr. Odou with regard to disfigurement, and then the last sentence is also out of there. I'm not sure why. I think all that language should be there as much as possible. That's all my only thought.
Well, Judge, this goes back to the admission of liability and causation by real water. So we're not instructing the jury that if you find them liable, you award these damages. They are liable. We're just instructing them to determine the amounts. That's the instruction.
Judge, I think there's a misunderstanding of what the term disfigurement means. It doesn't just mean scars on the face or things of the nature. In this case, the decedent was in a coma. They had to put a tube down her throat, which, as you know, rips the throat up pretty good. So there's some disfigurement in this case just from that. So we're entitled to instruction on that. Maybe it's not the type of disfigurement that if a supermodel got cut by with glass or something, the jury would give you 10, 20 million on, but there is disfigurement.
Well, I actually had a, I mean, I understand what you're saying there, but I think whether the disfigurement is permanent or temporary, I mean, that's kind of how I was looking. I just don't mind telling you this. And that's how I was thinking about it, because sometimes there's no question. I did a lot of dog bite cases to the race and then those types of things. Classic disfigurement, right? But it doesn't say permanency as far as disfigurement is concerned. So I'm going to leave it in, but just because, I mean, and I guess it can be argued in this case that it was permanent because she passed away. In contrast, say she was in a coma, she came out and everything was okay. It was transitory or not permanent, but nonetheless, that doesn't preclude her from saying, look, that's what it was. Because it doesn't really define it.
Thank you, Your Honor. That takes care of actually this one and the next one.
Yeah. Because I mean, and to be candid with everybody, I don't think it's a really big deal.
It's not a real big item, Your Honor, but
Yeah.
That's not,
Yeah, but I mean, I think the law would provide for it, that's all I'm saying.
Regarding Mr. Rasmussen's objection, could you change the word "you must also award" to the words "you must also calculate damages"? Which leaves, they may not.
Which one are we on now? I'm trying to, 10.16.
10.16.
What is this, what is it?
I mean, the SOC instruction says award, and the other instructions say how you determine the amount of an award, so we don't see any reason to change it.
Elizabeth, are you looking at 10.17 uses the word calculation?
No,
I think she's at 10.16,
I think
right?
10.16 has sentences that have been removed that say, if under the court's instructions you find that one, it has all that, which has been taken out because of real water, but again, there's that problem.
Interesting.
Yeah.
I understand. I'm putting a question mark by this. Try to work it out. If you can't, give me an alternative instruction. Right?
Yes, Your Honor.
Yes, Your Honor.
Sounds good.
Yeah, give me an alternative, because I'm not gonna sit and wordsmith it. And then I can compare them. But I can't see you must award. I mean, I understand it comes straight out of 10.16, but it does have a condition, right? It says if, under the court's instruction, you find that one or more of the heirs is entitled to a verdict, you must award, which is perfectly right. I understand there's a stipulation of responsibility in this case as to one of the defendants, but what impact does this language have on two defendants? Or other additional defendants? That's kind of. That's all. Because the jury can look at this and say, the judge said you must award damages, so everybody gets that. Is that the concern?
Yes, Your Honor.
Well, Judge, everyone must get damages, but there's still the check the yes or no as to liability.
No,
So,
I understand that, but it's not crystal clear in this respect, because one defendant has admitted responsibility and causation, there's no doubt about it. But two are fighting it aggressively. So, think about it, give me something.
yeah, I understand what you're saying. We can talk about it.
Yeah, that's all I'm saying.
Yeah, I understand.
Your Honor, we have not discussed yet the punitive damage sections at 10.20.
Well, before we get there,
That'd be a whole.
Is there another one that I missed?
Yeah, 1017.
10.17, I don't think there was.
Yeah, we gotta go to 1017.
page 45, 10.17, that's a
That's standard.
stock.
Yeah,
No objection?
It had the same disfigurement issue, and so we,
I've taken
the
care of
court
it. Go ahead.
we made a decision.
Yeah.
Page 46 is jury instruction 10.19, I think we agree on that one.
So that's okay?
one moment, Your Honor.
10.19, that's page 46.
Yes, Your Honor. We don't object, Your Honor.
Milwaukee doesn't make that.
Okay, we're talking about 10.19 here, right?
Yes.
10.19?
Yes, Your Honor.
Okay, good.
Page 47 and 48 is jury instruction 10.20. We modified the 1986 version in a couple ways. First, based on Real Water's admission of liability, the jury is instructed that they must consider whether to award punitive or exemplary damages against Real Water. The next paragraph, we go back to the stock language that if you find liability against Milwaukee and Hanna, then you may consider whether to award punitive or exemplary damages against them. I think the stock language is.
We're going to have to wait for the court's instruction on punitive damages as well. That particular motion was granted without prejudice. So I would suggest that at this point we table that for just a minute and we get to the chapter 12 one to get those done right now.
What's chapter 12?
What I
Oh,
meant.
you mean in the book, okay.
Yes, Your Honor, I apologize.
Just before we leave this one, Real Water had a different issue, which is the interesting issue, the 86 instruction said may. Apparently the 2018 says must. So in the
Or
first,
86, Your Honor.
yeah, so in the first sentence says, based upon real water's admission of liability, if we go into the 86 one, it says you may consider it.
Well, it's not discretionary on the part of the jury, they have to decide that.
May better than must.
Of course you can. That's why they say
Is that a surprise? Not a surprise.
Is there anything else regarding this instruction? I don't
No, that's just, we just thought that was an interesting artifact of the changing times.
Just to advise the court, there was another modification. The 1986 version provided for preponderance of the evidence. I changed that to clear and convincing.
I guess you don't object and change it.
No, that's the new law, that's the law that 1986 was overturned.
And then at the time of the
No objection.
At the time of the 1986 instruction, I think that their punitive damages, the amounts were determined as part of the initial phase one of the trial, so I modified it to advise that at this time you were to decide only whether any defendant engaged in wrongful conduct warranting punitive damages.
Do you want to put it in there?
No word.
I'm just telling them,
We're telling what we changed.
if you decide to award punitive damages and award damages justified, we will later decide the amount of punitive damages to be awarded after you've heard additional evidence and instruction.
How do you feel about that?
Still working on it.
How about we'll go to scintilla instead of preponderance of the evidence.
We got corporate
You have all these great ideas.
Clean up
Well,
corporate
this is-
America.
These ideas, and how they always benefit
He
one
wants to
side.
put in.
Shall not leave a gossamer thread.
That's the one I'd like.
Last more thread's good, I'll take that.
Want that one?
I'm a facial. How about that?
Near gossamer.
Must have video evidence.
I'm near a gossamer thread of malice.
Lunch.
What sounds good, Your Honor?
We actually made some progress. So we'll come back and circle back to it. We have to address it. We have to address it. So instead of 10 minutes, Mr. Rasmussen, it was about a half, about 30. It's okay. It was,
We got things done, Your Honor.
things done. I'm kept on checking that up. 1:30?
I will see you.